One of the reasons, as I said, they wanted to take out Trump and people like Flynn and freeze the Justice Department was to protect Hillary Clinton. And Hillary Clinton is in the middle of a battle with Judicial Watch about whether she will be deposed in person, about her emails, and more specifically now about whether or not she has to turn over her lawyer's record about the search and review process of her emails that led to the destruction of at least half of them, supposedly, because I know some people don't believe they were even deleted. So we had discovery granted to us on this issue by Judge Royce Lamberth. He said that he agreed with Judicial Watch. It was time to hear from Hillary Clinton and ordered her deposition. And Hillary Clinton filed an emergency motion. It's called a writ of mandamus. I was talking about one earlier, seeking relief from the court order, saying the court order needs to be overturned. Now, writs of mandamus are typically disfavored by the courts, and you have to have really good reasons. And Hillary Clinton's reason is that she's too important a government official, even though she left government 9 years ago, to have to be deposed by this. It's all old news, and she shouldn't have to be deposed. Even the State Department and Justice Department thinks that she doesn't have a leg to stand on legally in that type of objection. And these agencies were defending her in the lower court, so they didn't even want her to be deposed to begin with. But once the court order issued, they thought her appeal was bunk. They didn't say it like that, but that's essentially what the gravamen of their position is. So she filed this emergency appeal, and now the appellate court has set a hearing on that for June 2nd. So we are going to be in court against Hillary Clinton on June 2nd before a federal appellate panel. And it is a public hearing. I don't know if it's available online. I think they typically are now because of the coronavirus. They're not meeting in person, so it may be on something on YouTube. So as the time gets closer, I'll be sure to alert you to that. So we're fighting Hillary Clinton to try to get her deposed in person. And then we're also trying to get this discovery document that the judge also ordered be released. And it's a memo that we found that Heather Samuelson, one of Hillary Clinton's lawyers, wrote about her review and destruction of the emails. Of course, she doesn't say destruction. The email, the document is called the After Action Memo. And the court essentially said in a previous ruling that's applicable here, we think, that you can't hide everything because the court recognizes it's a memo written by the lawyer, so there might be a privilege in some of the information in there to the degree it reflects an attorney's mental processes or even recommendations. But the facts and details about what the attorney did are not subject to the type of privilege, or their interest in that privilege isn't outweighed by our need to know here. So the court said you got to turn over the document. So rather than turn over the document, Hillary Clinton is resisting the court order and saying we can't see any of the document. Any of the document. So we had to file a motion to compel against Hillary Clinton with Judge Royce Lamberth. And as the court found, and we remind the court, this is a rare Freedom of Information Act case in which the court determined that civil discovery is appropriate. On March 29th, 2016, he initially granted us discovery, and we didn't get the details of it till recently. But the court said that where there is evidence of government wrongdoing and bad faith, as here, limited discovery is appropriate, even though it is exceedingly rare in FOIA cases. Well, frankly, it's not exceedingly rare anymore because FOIA has been upended because of Hillary Clinton and that misconduct. Government wrongdoing and bad faith. Hillary Clinton was head of the State Department when those emails were being hidden from us. Secretary Clinton claims that the After Action Memo is subject to the attorney work product privilege and exempt from disclosure, but she fails to explain what the memorandum was created in reasonable anticipation of whether She fails to explain that the memorandum was created in reasonable anticipation of litigation, which is one of the key reasons you might be able to hold something back. She does not assert it was created due to the litigation here. Neither does she claim that it was created in anticipation of any other specific litigation. Simply put, she does not demonstrate that the after-action memo was not created in the normal course of the search and review process. So kind of a ministerial record, right? Second, the after-action memo falls within the category of contemporaneous documents shedding light on the three narrow discovery topics. And those topics, as authorized by the court, are: did Hillary Clinton use FOIA use her email system to avoid disclosure under FOIA? Did the State Department and company try to game the court into shutting the case down so we wouldn't find out about the emails? And thirdly, where are the rest of her emails? Were they all searched? So certainly an email or a memo about the review and potential, obviously, destruction of these records is important on all those points. Now, Samuelson, the one who wrote this memo allegedly, was granted immunity. She's the one who worked at the State Department, became Hillary Clinton's lawyer, supposedly culled all the emails for, quote, personal stuff, and then deleted them. And the Obama gang gave her immunity. We deposed her. And her deposition was something else. Because you know what? She told us that she was in fact aware that Clinton used email while she was Secretary of State. You know what she told the FBI? She did not become aware of Clinton's use of private email account server until she was serving as Clinton's personal attorney. Is Samuelson under investigation? Justice Department has this information. They were there during the testimony, folks. Is Samuelson under investigation for lying? I don't know. But they want to hide her memo. Hillary Clinton does. And isn't it interesting? Hillary Clinton is suggesting she can't give us this memo because it's a return to work product written in anticipation of litigation. Then why did she destroy all those emails if they thought there was pending litigation? She doesn't explain that. Why didn't she preserve all the emails? You can't have your cake and eat it too. You can't say, I was anticipating litigation and then destroy records responsive to any reasonable litigation that you could foresee. I don't know what's going to happen. I don't know what's going to happen with her deposition. I don't know I suspect Judge Lamberth is going to require at least some material be turned over to us here. At the appellate court, who knows what will happen. As I said, this is an extraordinary emergency case. Typically, it would be cast aside, in my view, rather quickly, or she wouldn't have a leg to stand on. But it's Hillary Clinton. So even though we had this big victory that Hillary Clinton has to be deposed under oath, even though then she went with this crazy appeal, she's Hillary Clinton, so she's going to get the time of day. And she has a right to make her case. That's fine. But if it were any other plaintiff, any other person trying to seek protection from having to answer questions about this type of misconduct, they wouldn't be given much relief from the court. But we'll see what happens here. The panel, I said, will hold the hearing on June 2nd. But this is why, I don't know, maybe Hillary Clinton's nervous because she still thinks she wants to be, I don't know if politics is behind this. Does she still want to be vice president or president in case Biden's mental health issues make it impossible for him to be the president? I don't know. Or be the candidate? I don't know. But they are very nervous about us questioning her. And if you've seen my colleague, Ramona Kotka, I've talked to her a few times. We have a few interviews here online. You can see why they should be nervous, because Ramona is a darn good lawyer, and she's going to ask good, she's going to be respectful, and she's going to ask tough questions and try to get answers about issues that Mrs. Clinton's never been questioned on. So we'll see what happens there.
Thanks for tuning in. Be sure to subscribe to our YouTube channel to catch all the latest news from Judicial Watch.